My name is Jed Stabler. I'm a partner in the law office of Stabler and Baldwin. I concentrate my legal practice in the area of estate planning, including probate administration and the administration of trusts. I've been practicing here in South Florida for approximately 15 years now. Having started my firm back in 1999 here in the West Palm Beach area. We provide legal services all over South Florida, Palm Beach County, and the state of Florida. Unfortunately, there aren't a whole lot of tax advantages when it comes to revocable trusts. Revocable trusts are what are called grantor trusts, which means that the assets in a revocable trust agreement are treated as if they're out there in your name alone. So one advantage would be that, you know, the revocable trust agreement, unlike an irrevocable trust, doesn't require you to obtain a separate tax identification number. So you don't have to file any special income tax returns. Everything remains under your own Social Security number, and the tax returns would just get filed just like they normally would. And some would say, sure, that's certainly an advantage to having a revocable trust agreement. The way that the revocable trust agreement avoids probate is quite simple. When you have a trust, the idea is to retitle all your assets in the name of the trust. By doing so, you're avoiding probate, because when you pass away, instead of those assets being out there in your name alone, they're already titled in the name of the trust. So, person passes away, assets are already titled in the name of the revocable trust agreement. The successor trustee that you name, that is to say, the person that you name, whose job it will be to distribute the assets, will simply need to contact the different financial institutions having assets titled in the name of the trust, would provide them with a copy of the trust if those financial institutions don't already have a copy, provide them with the death certificate, because those financial institutions are going to want to know that the grantor, the owner of the trust, has passed away. And once that successor trustee has provided that information to the financial institutions, they'll add his or her name onto those accounts, and once they're on those accounts as the successor trustee, they're going to be free to administer the estate pursuant to the terms of the trust. So simply by having the assets titled in the name of the trust versus titled in the decedent's name alone, you're going to be able to avoid the probate. You know, the question of whether or not a revocable trust provides protection from creditor claims is an interesting one, because part of the probate process is to notify creditors. I mean, part of that process is notifying the creditors, sending them notice that the estate's been opened, and you actually give them an opportunity. It's a 90-day a creditor period in which the creditors have to file claims against the estate. Well, with a revocable trust agreement, creditors are dealt with a little bit differently. In the trust statute here in Florida, a trustee of a revocable trust is only legally obligated to pay enforceable claims of creditors. Now, to be an enforceable claim of creditor, if you haven't already filed a probate, means that that creditor, before that trustee is legally obligated to pay that creditor actually has to go to court, open up the probate themselves, appoint somebody as a personal representative, file a claim against the estate, and only then would the personal representative of that probate of the probate estate forward the claim onto the successor trustee or the trustee of that revocable trust agreement. So when it comes to creditor claims, it's a little more difficult for creditors to the extent that you have a revocable trust agreement. Again, it's one of the benefits to having that revocable trust agreement versus a plain last will and testament, and that is it makes it a little more difficult for creditors. Thank you for joining us today and watching our video. I hope you've learned a little bit about what we do and revocable trust agreements and probate. Please feel free to contact the firm either via telephone at 561-471-7100 or through our website at jedastablerpa.com.